All right, back on the record after a short break. I know that Mr. Bristow and Mr. Tilly would like to make hopefully relatively short comments. I'll turn to Mr. Grammett afterwards, hoping he doesn't need to make comment, but I have to offer him the opportunity, so I'm gonna turn to Mr. Tilly and Mr. Bristow, whoever wishes to speak first.
May I speak from here?
Of course, and you don't really even need to stand up if you don't want to.
It's an old habit. Thank you.
All lawyers have that habit.
I'll be very brief. The one thing I want to clarify so that there's some balance here is the hypothetical that you were asked earlier, Commissioner Centarini, left out one vital fact. Fact is, in an email the night before Mr. Thorson and Mr. Patton went to Philadelphia, Mr. Patton told Mr. Thorson that he would take care of the lunch. Thank you.
Fair enough. Okay,
Well, you're right, I think in the context of,
as I say, fair enough.
thanks. Be a little longer than that, I promise I'll be short.
You'd have a hard time beating that.
Look, I think one of the first things that was said to you by the prosecutor is that the hearsay rule, is in place not to confuse jurors. That's just categorically false. Okay. Hearsay rule is to foster the truth coming out during a trial or a fact-finding mission. I mean, the United States Supreme Court has said the most valuable tool that can be utilized by anyone in terms of arriving at the truth in any legal decision-making process is cross-examination. And guess what eliminating hearsay allows you to? It allows you to ask the person who says the statement was made questions. You get to cross-examine the person who said the following. You know, this is an out-of-court statement offered by someone who's not here before you. Okay, and it's not, the hearsay rule does not exist to, it doesn't exist to avoid confusing jurors. It exists to foster the truth. And any representation other than that is, I just can't have an explanation. Two, as it relates to, the whole concept of, Rule 403 and visibility and confusion, of fact finders. I don't think that the rule anyway distinguishes between jurors and, for example, a judge waived trial. I think the rule is the rule, and I think it's applied universal. And I think that's important. The other thing I'm going to say is that we've heard some things about AFER requests. There's all kinds of law about, the access to records laws and statutes and findings and things that are going on. But I don't think that something being determined as a document of any kind, being determined as being subject to disclosure pursuant to the AFER statutes makes it admissible under Rule 8038, which is the definition in the rules of evidence of public records. You can say public records, you can use it in connection with the certifications that were here, but there is a legal definition for public records. You have advice of counsel here, so many of you are lawyers, but I'm just telling you that just because something is disclosed pursuant to AFER does not mean that it is admissible as a public record under the rule 8038. All right. Yeah, I think that's all. I think that you're not gonna try not to do it appropriately, but you're being offered in terms of the potential relevance or stated relevance of the documents that the prosecutor went through with you. Asking you to make some quantum inferences in terms of what's going on, what's being observed, who's observing it, what information is being provided, who is actually receiving that information, when they receive the information. Okay, and I think that those are the sorts of things that you need to consider when you're looking at how you're making decisions regarding relevance. And I guess, since arguments were made to you, assessing the arguments that the prosecution's making regarding drug enforcement's conduct. Thank you so much.
Yeah, Mr. Bristow, I don't mean to be critical,
Sir.
but I quote from Deepest Swallow.
Okay.
Many of the rules surrounding the exclusion of hearsay in jury trials are meant to prevent juries uninitiated in the evaluation of evidence from hearing unreliable or confusing testimony and rendering a verdict based on such evidence. Just say, I don't think your comment that that's just not what it's for is supported by what the Supreme Court has said.
Okay, in connections,
And you could respond, of course.
yeah, just give me 1 second.
There's more in Deepest Swallow, don't get me wrong,
Right,
but I'm responding to the one comment you made, that it's not about protecting. It is about, in part.
it's from confusion, Mr. Chairman?
Right.
Yeah, and nothing to do with hearsay is designed.
It's all about hearsay. The admission of hearsay evidence in an administrative forum is reflective of the traditional division of function between judge and jury. Many of the rules surrounding, part that I read after, surrounding the exclusion of hearsay in jury trials are meant to prevent juries uninitiated in the evaluation of evidence from hearing unreliable or confusing testimony and rendering a verdict based on such evidence. So I'm only commenting on your reaction to what Mr. Graham had said, that there is at least a basis for what he said.
Oh, thank you.
Yeah, just a quick follow-up.
Oh, sure.
Kelly. Sir, can you just share with me your thoughts relative to what your response to Commissioner Santorini relative to Mr. Patton saying he would take care of it? What do you mean by that?
Well, he sent an email to Mr. Thorson the night before saying that he would take care of lunch the next day.
Take care of me. With,
I can't speak to how Mr. Thorson understood that, you will hear that. But I can tell you,
I'm curious as to Mr. Patton still being a subordinate to Mr. Thorson and still being some level of ethical.
Yeah, that may come up.
Fair enough.
The
Thank you.
context, just as for context, I believe Mr. Patton stated that in an email to Mr. Thorson, where he maintained that Thorson picked up the bill at the ladder company when the employees were up. You paid this bill, I'm gonna pay the next one. That's my recollection of the investigative report. And I only offer it for
It's
context.
important. I wasn't here for the first half of that. So that's correct.
Mr. Graham?
Very brief, very brief. First, I want to thank you for making that comment. I don't often hold that something I say is category false. Being an attorney. I want to thank Mr. Kelly for bringing that. Wasn't one of the exhibits they objected to, but it's one that I put because I figured they would want it. Saying thanks for dinner last night, but on a budget like me. But again, I thank Mr. Kelly because that is my whole point. The reason all my exhibits regarding what the timing of Mr. Thorson being told about David Patton's conduct is relevant. Was it reasonable for him to have relied on the guy who sent an email? He didn't mention that this email came past midnight the night of the. So all of these things having to do with what he knew, what his chief of staff told him, what someone else told him, is relevant to whether or not he should reasonably.
Right. One thing I can say without any questions, we've given the parties full and fair opportunity to discuss this motion. Been told by our counsel, need to go through these one at a time. But I guess I'd like to ask the commissioners on a more broad way, whether anybody has a broader thought about how to address all the motions, some of the motions, as we go through them.
Can I make a suggestion?
Yes, please.
Good to hear from our legal counsel, just the effect of approving or denying the motion of what that's gonna do. And then, let's say, evidence comes in, briefly explain for those that there doesn't mean that you have to accept it. You have to talk about the probability, credibility, and that kind of thing. Just to understand what we're voting on for folks that don't know.
So
The motion has been made by the respondent.
Bert, can you please speak up?
Oh, sure. So the motion has been made by the respondent to exclude, I believe, 23 different proposed exhibits put forth by the prosecution. Right, so you can either grant or deny the respondent's motion as to each of those exhibits, or you could defer ruling on the motion as to any particular exhibit if you don't believe you have enough information now to make that decision. If the exhibits are admitted at trial, and again, as the chair stated, the prosecution is going to have to begin at the trial with respect to all of these exhibits, but if they're admitted, then it's admitted subject to the weight that you are going to give it. You may give it a lot of weight, you may decide it's, while relevant, it doesn't carry much weight with me at all. Okay, that's for a later determination. And you'll make that determination based, not in a vacuum, but in the context of everything else that comes in the hearing.
And if denied, it can still be offered at the trial.
Correct.
Right, I just.
Correct.
Want to leave
And
that.
there may be other avenues by which the parties may try to seek admission of the hearing.
Depending on testimonial evidence.
Correct, right.
So. I guess I have to go through each of these exhibits. And I think what I want to do is see if there's a motion any commissioner would like to make with respect to exhibit 3. Grant, deny, defer, I think are our choices.
That's the Department of Administration webpage.
I make a motion to accept.
Well, no. Are we, let's just so we're clear, we're ruling on the respondent's motion. So if your thought process is webpage should come in, then you would be moving to deny the
Okay,
motion.
thank you.
And we should be clear again that a denial is not the final word necessarily. Unless we decide at the next hearing that our ruling was definitive, whatever's offered, we have to reconsider based on arguments made at that time. And we have the right to say, no, we've dealt with this previously, it's definitive as far as we're concerned. Or we could say, hey, that's interesting, you brought up a good point, maybe it is relevant, maybe we should let it. Oh, Mr. Bristow, that's a point we hadn't considered, maybe we better keep it out. So that can still come up at trial. What's important here is that they've brought to us claims about these exhibits. And we can consider today whether we think a sufficient presentation has been made to grant the motion to exclude, deny the motion to exclude, or defer on the exhibit.
Or defer the motion to.
Defer, it's effectively defer on the exhibit because the exhibit's then going to be presented at the trial where the issue will get decided. So on exhibit 3, is there a motion? You meant to make a motion to deny.
Right.
Is there a second?
Second.
Now, I want to be clear that I have only a vote sheet here for one column, so I'm hoping that our staff are taking careful notes on these because I don't have enough places to put all these things down.
Yes.
All right, so
We're also recorded, so we'll have.
yeah, I know, but my purpose is, so we have a motion to deny the motion to exclude with respect to exhibit 3. And it's been seconded. Any further discussion? Hearing none, roll call vote, Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
Aye.
Commissioner Cederini,
Aye.
Commissioner Ravidu,
Nay.
Commissioner Ritchie.
Aye.
And the chair votes aye. The next one is Exhibit 4. Is there a motion on Exhibit 4? And I want to, I'm asking them this way, rather than specifying which way they might go. So that I'm not the one
Right.
setting how we're gonna discuss this. So you, each of you, when you make the motion, whoever makes the motion needs to, as Commissioner Cederini did, to indicate what it is the motion is to be relative to the exhibit.
Exhibit 4 is the job posting, State of Rhode Island Division Director, Capital Asset Management Maintenance, DOA.
Is there a motion?
I move to deny.
Is there a second?
Second.
Second by Commissioner Susie. Roll call vote, Commissioner Susie,
Aye.
Peterson,
Aye.
Commissioner Callahan,
Aye.
Commissioner Cederini,
Aye.
Commissioner Rabideau,
Nay.
Commissioner Ritchie.
Aye.
Chair votes aye. Again, on the next exhibit, which is Exhibit 5, the DOA request for proposal. Is there a motion?
I move that we deny.
Is there a second?
Second.
Second by Commissioner Cederini. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Cederini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. Exhibit 6 is next. And that was the scout proposal in response to the RFP that was Exhibit 5. Is there a motion? Is
I'll move to deny.
there a second?
Second.
Second by, motion by Commissioner Peterson, second by Commissioner Cederini. I'll ask again if there's further discussion, but I'm gonna say on the next of these, if anybody wants further discussion, let me know. I just want to move on through this if possible. So we're on Exhibit 6. Is there a motion, or do we have a motion? All right, so there's been a motion by Commissioner Peterson, a second. I've forgotten who made the second at this point. I think it's maybe you. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Cederini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Next item is Exhibit 7, agreement for pre-development service. Is there a motion?
Motion with respect to the respondent's motion, correct?
Correct. All the motions relate to whether we're going to grant, deny, or defer.
I'll move to deny.
Is there a second?
I'll second.
Roll call vote. Well, again, if anybody wants to make discussion, get those, let me know, but, roll call vote, Commissioner Susan.
Aye.
Peterson,
Aye.
Commissioner Callahan,
Aye.
Commissioner Cederini,
Aye.
Commissioner Ravideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. Great.
Number 8, that's the invoices from Scout to DOA.
Is there a motion?
I move that we deny.
Commissioner Susan to deny it. Is there a second?
Second.
Second by Commissioner Cederini. A roll call vote. Commissioner Susan.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Nay.
Commissioner Cederini.
Aye.
Commissioner Rabideau.
Nay.
Commissioner Ritchie.
Aye.
Chair is conflicted. The chair will vote aye in order to move this along. I'm not sure what the vote would be if I said nay. My position would be perhaps.
I've got 7.
defer.
Yes, 7.
So we
No,
all right, I'm gonna leave my vote at that. At where it was, which was to agree on the motion. The next was number 9, the email thread between James Thorson and Everett Abbott. Their motion.
I move to, nine.
There's a second,
Second.
roll call vote. Commissioner Susan,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
Aye.
Commissioner Cenorini,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. Exhibit 10, email from David Patton to Christopher Farrell with copy to James Thorson. Is there a motion?
I'll move to deny.
By Commissioner Peterson, is there a second?
Second.
Second by Commissioner Cenorini, a roll call vote. Commissioner Susan,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
Nay.
Commissioner Cenorini,
Aye.
Mr. Rabideau,
Aye.
Commissioner Ritchie,
Aye.
and the chair votes aye. Exhibit 11, email from Jonathan DePault to Lindsay Scannafieco and Everett Abital with copy to David Patton. Is there a motion?
I move to deny.
Go second.
Second.
Roll call vote. Commissioner
Aye.
Peterson,
Aye.
Mr. Callahan,
Aye.
Mr. Cenorini,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie,
Aye.
and the chair votes aye. Is there a motion on exhibit 12, email chain containing inter alia messages from Jonathan DePault to Amanda Rivers with CC to James Thorson?
I move to grant.
Is there a
Is that the
second?
one, is that the one with the redaction? I second.
Is there? All right, there's been a motion made to grant the motion with respect to number
Well,
12. Take a roll call vote. Commissioner Susie,
No.
Commissioner Peterson,
No.
Commissioner Callahan,
Nay.
Commissioner Cenorini,
Aye.
Commissioner Rabideau,
aye.
Commissioner Ritchie,
Nay.
again, knowing that this has come back before us potentially, I'm gonna go with the nay also. Now, I guess that means that motion has been voted down.
Therefore, the opposite vote.
It was 2-5. So it's.
Yeah, my question is, do we have to go to the other side? I mean, it seems to me that if we've rejected a motion to grant, unless someone wants to make a motion to defer.
I would
Then
like to make a motion to defer.
All right, motion to defer made. Is there a second? Second. Second by Commissioner Callahan. Roll call vote. Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
Aye.
Commissioner Cenorini,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie, and the chair votes aye. Commissioner, I'm sorry, exhibit 13, email from Everett Abital to David Patton. Is there a motion?
I move to, deny.
Is there a second?
I'll second.
Roll call vote. Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
Aye.
Cenorini,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Page 2. Exhibit 14, email from David Patton to Everett Abital and Lindsay Scannafieco sent on February 23rd, 2023. Is there a motion?
I move to deny.
Is there a second?
I'll second.
Roll call vote. Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Callahan,
No.
Commissioner Cenorini,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes. I'm sorry, the chair, sorry, but you were asking me, the chair votes aye as well. Exhibit 15, email from Danielle Demuro to David Patton, March 8th, 2023. Is there a motion?
Motion to deny.
Is there a second?
Second.
Roll call vote. Commissioner Susie.
Hi.
Mr. Peterson.
Aye.
Callahan.
Aye.
Mr. Centerini.
Aye.
Mr. Ravidu.
Aye.
Mr. Ritchie.
Aye.
Chair votes aye. Exhibit 16, email thread among James Thorson, David Patton, Nancy McIntyre, Thomas Govis, and Christopher Farrell. March 9th, 2023. Is there a motion?
Motion to grant. Excuse me, motion to deny, I apologize.
Motion to deny on the floor. Is there a second?
second.
Second by Commissioner Susie. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Ravidu.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. The next one is exhibit 17, an email thread among James Thorson, Libby Kimsey, Everett Abbott-Troll, Lindsay Scannapieco, and Daniel Demuro, March 27, 23 through April 7, 2023. Is there a motion?
I move to deny.
Is there a second?
I'll second.
Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan. Sorry,
No?
Commissioner. That was only because I didn't hear it.
No, that's okay. No, that's fine.
Commissioner Centerini.
Aye.
Commissioner Ravidu.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Exhibit 21,
I have a question for,
yes,
can you explain to me again what it would mean to defer? What happens?
defer means we make no ruling now. And that means that when it comes before the commission the next time, we cannot apply the definitive ruling approach. If we've made a definitive ruling today, then we don't have to reconsider arguments at the hearing. If definitive ruling, which would be deferral, then we have to open the floor to arguments on a particular exhibit.
Okay, thank you.
That's my take on it, at least.
Yes.
I should do that, it's really should be
No,
you.
well. That's correct, except that the prosecution has to offer all the exhibits and the respondent has to object to preserve the record. And also, if one of the parties presents expanded arguments we haven't heard, we could reconsider.
That goes to the definitive piece. of it.
Correct.
But it,
That's if we deny.
the question is what happens if we defer?
If we defer, we haven't made a decision. Okay, so when they come back on March 17th, we're gonna hear it all over again and they can argue to their.
Has it been seconded?
No, I just asked.
Never got to the,
clarification
never got this.
Before getting to that.
So this is on exhibit 21, is this right? No, it's not, it's exhibit,
Yes,
Exhibit
21.
We're on 21.
okay, exhibit 21, yes. The email from Jeff Britt to Tony Afonso dated March 12, 2023. Is there a motion?
I move to grant.
Is there a second?
In,
You mean,
sorry,
you mean grant?
grant the objection.
Yes.
Okay, you move to create the motion to exclude the document.
Right.
remaining minutes.
Right. Is there a second? There being no second,
I move to defer.
I'll second that.
The discussion,
sure.
it, to me, I respectfully can't support it because it seems to me that it's hearsay upon hearsay and it's unduly prejudicial to the respondent. To let in the communication from Britt to the governor, including the information that came from the two parties in Philadelphia regarding the allegations.
And if I can, I think I want to read the affidavits of the two parties from Philadelphia because Mr. Bristow made the point during his presentation that they didn't John match. And that's why I figured if we deferred it, I'll have more information available to me, and if we have to take the matter up at the hearing on the seventeenth, I will be in a much better position to.
And your concerns will then be addressed in that.
I just ask one clarification of the parties. I believe that someone said that the parties have stipulated that the affidavits can come before the commission.
The affidavits of Mr. Abbott Paul and Ms. Canapico, those the affidavits.
No, the affidavits that apparently the parties have taken from,
Yeah, those are the
witnesses.
scout witnesses,
Yeah,
the principals of scout.
Yeah, exhibits 32 and 33, I heard.
did the party stipulate to that?
I don't know.
You want me to address that?
I heard that they stipulated to the admission.
Right. I'll let
of the
Mr.
affidavits.
What, we received 33 documents from the prosecutor. We went through them, we entered the objections and found this motion to exclude. My understanding when we received those are documents which the prosecutor intended, certainly had no objection to enter. I think today he said, you know, I'm offering those to you, or they're gonna be offered into evidence. So there's no written stipulation yet as it relates to those two documents, and I don't know if they would be subject to it, but it's my full understanding, 2 weeks before trial, is that those affidavits of Mr. Abbott Ball and Ms. Canapicio are going to be admitted into evidence before you.
By stipulation of the party.
Yes, that's what we'll do, Judge. Yes, Your Honor.
Can I ask another question just for discussion, so discussing this, was this the one that it was mentioned that potentially, the Attorney General had said was
Yes.
a public record?
That's the one.
Okay.
Just from my clarification, was it your statement, Mr. Best, about the other parties in Philadelphia? They sat for depositions, or they have not?
No, their depositions were noticed in lieu of a deposition. They agreed to sign with counsel down there. They agreed to sign, each of them signed an affidavit that we believe contains the relevant interaction.
And based on an agreement between you and Mr. Grammett, correct?
No, that was based on, we filed, because that's correct. We filed the motion to take their affidavits.
Correct.
The commission gave us permission to do that. We had to go to court here and then court in Philadelphia, Pennsylvania to get permission to do that. We were in communication with them, and then on our advice, they got an attorney. We're in communication then with their attorney, and they agreed to, rather than be deposed, that is, Mr. Grammett, at least one of us come down and actually ask them questions on the oath. They agreed to sign a written statement under oath, an affidavit, in lieu of being deposed. But that was between us meaning Mr. Thorson's counsel and the two would-be deponents in their counsel down in Pennsylvania. Mr. Grammett had nothing to do with that, other than if he wanted to take the depo, it was set up.
I mean, that's kind of what I'm getting at, is he's not had cross-examination. So was this affidavit the result of his knowledge and your knowledge, or was it simply an affidavit prepared by these two people? I'm gonna cut through this though, because if you're gonna present them, then my question to you is, are you gonna object? If you know.
The answer is no.
Oh.
I certainly could object because I've had no right of cross-examination, but my theory is, let's just let you take a look at it, and just like everything else, then you can give it the way you want.
Again, my opinion would be if we defer, we have all three. And now we can look at them all and make a decision accordingly based on the information in all three.
Well, you might not have the affidavits though by the time this is up. Depends on when.
We're
the
gonna have
court-
any affidavits before
No,
trial.
no, we
We will?
you will have these two affidavits available to you.
Okay.
For,
Thanks.
so we visit this motion.
Okay.
Before we revisit the motion.
Before we visit the motion,
Right.
okay, right.
So I think we have a motion for, and I believe we have a second. And this is on exhibit 21.
Correct.
Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centarini.
No,
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Next one is exhibit 24. Text exchange between Libby Kimsey and James Thorson on March 9th, 2023. Is there a motion?
I move to grant.
I second.
Motion to grant before the commission, a second before the commission. Any discussion? Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Sorry. Commissioner Callahan.
Aye.
Commissioner Cederini.
Aye.
Commissioner Rabideau. Commissioner Ritchie. This is not a motion to grant the motion, correct?
Yep.
Right, where is it?
My vote is nay. The next one is exhibit 26. An email from James Thorson to Libby Kimsey on March 12th, 2023, containing forwarded email from Brianna Ruggiero to Elena Mertes and Paul Dion. Is there a motion?
Move to grant.
Second.
It's a motion to grant the motion to exclude. There's a second. I'll take a roll call vote. Commissioner Susie. Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Cederini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Nay.
And the chair votes nay. The next one is exhibit 27, the email from James Thorson to Pamela Mascarelli and Libby Kimsey on March 12th, 2023. Is there a motion?
I move to grant.
A second. Hearing no second, is there a motion either to deny or to defer?
I would move to defer.
Is there a second?
I'll second.
Second by Commissioner
And,
Peterson.
and I guess just as a matter of discussion, it was because, prosecution acknowledged that it ties in with 21 and 31 as part of it. So I think if we're deferring 21, it would be wise to defer this one as well.
We have a motion and a second. Roll call votes. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Cederini.
No.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. The next one is exhibit 28, March 3, 2023 text message from James Thorson and Christopher Farrell regarding visit with Bach BOK. Is there a motion?
I move to grant.
Is there a second?
I'll second.
Motion to grant the exclusion of this document. And a second, a roll call vote, Commissioner Susie.
Which number is it?
We're at number
28.
28.
That's the March 3, 2023 text message between James Thorson and Christopher Farrell regarding upcoming visit to Park.
There's a motion to grant the exclusion. Roll call vote. Well, further discussion on that one? Okay. Roll call vote. Commissioner Susie.
No.
Commissioner Peterson.
No.
Commissioner Callahan.
Aye.
Commissioner Cederini.
Oh. Just clarify the motion again for me.
Yes, the motion.
This is to grant the objection.
This is a motion to preclude exhibit 27. And the motion before us is a motion to grant. Is that correct?
Yes, we're
28,
moving
the
to,
grant, right?
the motion is to grant, the motion to exclude this proposed exhibit 28.
27, 27.
28,
28.
we're on 28, which was the March 3rd, 2023 text message.
Yes.
Between James Thorson and Christopher Farrell regarding the visit to Bach.
We have a motion to grant. We have a second, and we started the roll call vote, but I'm gonna start it over again. Commissioner Susie.
No.
Commissioner Peterson.
No.
Commissioner Callahan.
Aye.
Commissioner Cederini.
No.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
No.
The chair votes no. See which one I was going. So that failed,
Failed.
so that motion failed,
Yes,
and we decided before,
so we can either move to deny or move to defer at this point.
I move to deny.
A second,
any further discussion? Roll call vote, Commissioner Susan.
Aye.
Commissioner Peterson.
aye.
Commissioner Callahan.
No.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Nay,
Commissioner Ritchie.
Nay,
The chair votes aye.
Carried 4-3.
The next is, there is a motion on exhibit 29, the March 11th, 2023 text messages between James Dorsey and Christopher Farrow regarding visit to Bach. Is there a motion?
I'll move to deny.
Is there a second?
Second.
Roll call vote. Once there's further discussion, Commissioner Susie.
Aye.
Susie.
Susan.
Commissioner Peterson.
Okay.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Mr. Ritchie.
Aye.
Chair votes aye. Let's go to 29.
We are on exhibit
30, all right. Exhibit
number 22.
30 is exhibit. Is March 12th, 2023 memorandum Ray Bach site visit from David Patton to Director Thorson. Is there a motion?
I move to deny,
Second.
Roll call vote. No discussion, roll call vote, Commissioner Susie,
Aye.
Commissioner Peterson,
aye.
Mr. Callahan,
Aye.
Mr. Centerini,
Aye.
Mr. Rabideau,
Nay,
Commissioner Ritchie.
Aye.
And the chair votes aye. And last but certainly not least is exhibit 31, the March 2023 email forwarded from Jeff Britt, Tony Alfonso, and subject line Friday store with Patton and Thorson. I believe it's been represented that this is essentially the equivalent of exhibit 21.
We move to defer.
To defer. Is there a motion for the commission?
move to defer.
Move to defer, Commissioner Rabbit, is there a second from Commissioner Callahan, roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
No,
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
aye.
The chair votes aye. All right. So the chair suggested to me that.
go the chair.
I'm sorry. Council, been a long day. Council has suggested to me that this should be reduced to some form of order. Staff has been taking notes on this, so I would suggest that staff prepare the order, put it in front of Mr. Bristow and Mr. Kelly. I don't think, yeah, let's see if you guys can agree on it. If you can't, then it'll come to me. Okay. That concludes number 4 on the agenda. There's only new business proposed for future commission agendas. Seeing none, is there a motion to adjourn? A motion for Commissioner Susie, second.
Second.
May I cast a single vote? I'll just take a quick vote. Commissioner Centerini.
Yes.
Commissioner Rabideau. Commissioner Callahan, Commissioner Peterson.
No.
Commissioner, I've got it.
Right.
And the chair votes.
Thank you all for your time.
Thank you.